was really good for us to have you. And we are very fortunate to have you again this year. So thank you again, Professor Andreas Kotsios, to be here. Professor Kotsios is passionate about law. He has his PhD on the theme payments with data, which is the thing we are talking today, in information technology. He's also a struggling programmer. He has a lot of abilities. He's currently doing a postdoc at Uppsala University in Sweden, focusing on legal issues related to the application of artificial intelligence in financial markets, and teaching a number of courses related to this theme and IT. He has his PhDs in European law, with the subject. He has also an LLM in law and information technology from the University of Stockholm, and he's a member of the Athens Bar Association. So Professor Andreas Kotsios is actually from Greece, and he was really, really kind to talk to us in English today, because our Greek is not as good as we wish it was. So,
yeah, I want to thank you. It's really an honor being here. And if sometimes I start speaking in Swedish, please but understand that I have like 2 kids. I talk to them in Greek. I'm teaching in Swedish, and then I'm also like writing in English. So it's like my head is a bit like sometimes it's difficult to understand which language I'm using. But I will do my best. Then I will try.
Everybody English is a little rust, so please be also patient with us for that. Students may have questions, they will write on the chat. If they come in Portuguese, I will translate to you. If they come in English, you can. So please, Professor Andreas, you have the floor.
Yeah, I will try to share my screen actually. See if it's going to work. It's on with, yeah, here. Do you see my, yeah, super.
Perfect.
Then I would, so thank you everybody for being here. As Laís said, I generally like examining technological issues that have some legal aspects. So I have a master's in law and IT. I did my PhD in EU law, but the focus was actually on I examined what we call here in Europe regulatory contract law. So it's like contractual relationships and how they're affected by regulation that comes from mostly from the EU. I've worked as a maritime lawyer actually, like 5 years. Very different thing, but I always loved, as I said, technology. So I have been a programmer. I'm also in a project about consumer chatbots, which I hope we continue with this project. And my current project at the university is about AI in the financial markets. But I would like to talk about my actually the project I was working with in my PhD, which is about payments with personal data, and examine how consumer law has started like a new trend that we've seen in Europe the last, we say max 8 to 10 years, where we started, many authorities started using consumer law in order to protect consumers' personal data. And I'm not that acquainted to the Brazilian system, but I know that you have what is it called, LGPD, the Brazilian GDPR. So I know that you also have this, 2 areas of law that are probably not the same, because will be like, I will try to say, first of all, how it all started, why, like, for example, like come with some examples, like where consumer authorities started talking about applying consumer law in order to protect consumers' personal data, and also like what the literature, like a shift that we saw in the literature and academia. And I will continue by elucidating a little bit more the connection between consumer law and data protection law, because there are, of course, like as I will show, like many things that are like they look alike, but they are not. But it create they create connotations and connections. Then I will continue by like bringing the arguments on why consumer law has been in a way seen as a good way to protect consumers' personal data. And then I will end up with some concluding remarks, and so that we can also discuss if you have any questions. And I would be very glad if some of you could also like tell me how it is in Brazil, actually, like how consumer authorities, because it's mostly authorities actually that try to tackle data protection issues through consumer law, or if you like, I don't know how it is in academia. Like you are very welcome to tell me how the situation is there. So one thing that can be like, I don't know, problematic for you maybe, is that it's a very like European approach that I'm using here. So I will try to do my best so that you understand also the context. But yeah, so we can start with some very basic information, because I mean, when we talk about payments with data, it's I mean, probably everybody has heard this notion that there is some kind of payments with data that takes place whenever we use, for example, like, I don't know, social networks or different like services on the net. And the classic understanding is that payment is that you give some money, you buy something and you give some money. And our generation actually is the first one that has been so much indoctrinated into the idea of payment, like no other generation before, because like if we go like, I don't know, 100 years ago, in most places it was still like barter relationships that we were like that were the main paradigm. But if someone told you like 20 years ago that most services that you use right now, at least most digital services that were provided to you for free, you would probably think that this person was crazy, because until like 20 years ago, max, I don't think that there were so many services that you could use without paying anything. But right now, for example, I'm using approximately, let's say, like, I don't know, 10 applications per day, which I regard as vital because I use them the whole time. And it can be, I don't know, reminders, taking notes, parking, finding, videos, news, for which I pay nothing. And all these apps seem to be provided to me for free. But as the old saying goes, there is no such thing as a free lunch, right? So there has to be some kind of remuneration so that the traders can make money. And considering that we are indoctrinated to the idea of paying, there is, of course, this connection directly that what we give is the payment. And what we give to traders is, of course, not, it's personal data. So if we see also like the language that was used in the beginning of 2010, like after 2012, maybe, we see, I think it was 2012, when the EU Commissioner Viviane Reding stated that personal data is a new currency in today's digital market. And then we've seen, like, for example, the World Economic Forum was talking about personal data and the emergence of a new asset class. We have heard about personal data as raw material, personal data as a commodity, personal data is the blood in the veins of the digital economy. And of course, here in Europe, we also got a new directive, the Digital Content Directive, where when it was still a proposal, it was proposed in the text, we could find the idea of personal data as a counter performance. And even though it didn't end up in the final text, it nevertheless created some connections there. So if paying with data was a traditional payment, consumers should be protected under the consumer law framework. And that includes, for example, EU consumer law provisions transposed into national private law and market law legislation, regulating mainly the behavior of traders. For example, traders should provide specific information. They should provide the information in a transparent way. This information should be about the product, the price, the payment agreements. And at the same time, since the payment constitutes the counter performance by the consumer, and therefore indicates the existence of a contract, the terms of such a contract should also be fair, or at least not be unfair. Because we have, like, for you that don't know, and I will get into that a bit more, we have like two main, like, let's say, universal consumer laws in EU. The one is Unfair Commercial Practices Directive, that is mostly about how traders promote their product, but it extends to any kind of like of practice. I mean, it can also be, you know, the contractual terms that traders provide to consumers. And then we have the Unfair Terms Directive, which is specifically about the unfairness of contractual terms. So through these two, mainly through these two pieces of law, consumers would be empowered with a number of rights that they might enact just in case the purchased product was not provided as promised, or if it was not objectively okay. And in such traditional payments, the focus of consumer legislation would fall on the obligations of the trader against the consumer, and then the correlating rights of the consumer against the trader. But one of the main considerations concerning such payments is not merely related to the fairness of the exchange as such, but it is also linked to possible danger that personal data may be used for malevolent or manipulative purposes, and meaning, like, you know, the loss of privacy mostly. So this is the, like, something new now when we talk about consumer law in the context of data processing. So in this case, the question is actually, is it really a consumer law issue as we understood consumer law until now when it comes to data processing? And why should we include the processing of personal data as something that is related to consumer law, considering that there is already some piece of legislation that is specifically created for the protection of individuals in general, and therefore also the protection of consumers when their data are processed? And I mean, of course, the GDPR. And this has been the main question which I tried to examine in my research, because I got mostly, like, very interested into that. And it was also like to give some historic background also of my research. I was a fellow in Amsterdam, actually, and there were some scholars that were like some of the first that started to write about this new trend, and like if consumer law can apply and why it should apply, and what are the, like, you know, the positive effects of such an application. And I remember I was, because I really like the idea, because I already had started writing about that. And then I met one professor there. I don't know if you know him, Hesseling. And it was very interesting because I started like talking to him about my idea and talking about contract law and how, you can use this. He's like, why are we going to use contract law? Why is it the contract when you provide your data? And this is where I started like thinking more about it and like taking a step back and thinking, okay, but yeah, okay, I mean, why do we have to do that? What is the added value? So my question was mostly about what is the added value of using consumer law when we already have data protection law. And again, the focus is on the processing of personal data. I didn't examine, for example, like how this processing can affect, consumer patterns, or how you use, for example, how you purchase with money other products that may violate your privacy, or they don't have like a good privacy, policies. Because there you pay money, so it becomes directly like a matter of consumer law. So here we come like to the first, to the first step in order to understand like why we started using consumer law for protecting consumers' personal data. Because again, I mean, it sounds quite like persuasive. I mean, why shouldn't we do that? If you are a consumer lawyer, the first thing that you are going to think is that, yeah, of course, it's a consumer like issue. Consumers like use social networks. Consumers use all these free apps. So of course, it's a matter of consumer law. And this was my first, my first idea that, yeah, of course, we are going to use it. And the problem is just how we are going to do it the best way we can. And the reason for that is that there are so many things that are like so common in like common patterns that we find in both frameworks. I mean, the parallelity of data protection and consumer law is really not hard to notice, They both focus on protecting the weaker party in a relationship, be it the consumer or the data subject. And if we consider that at some point we all are either consumers or data subjects, there like the applicability of these two frameworks is almost like universal. I mean, like both for consumer law, but especially like when it comes to data protection law, there are some scholars that are saying that data protection law is the law of everything, because everything can be included there. So if we even think like, what is their main like yardstick in order to be able to assess what kind of protection we have, we find the same notion, the one of fairness. We have, for example, the Unfair Commercial Practices Directive on the one hand, and the Unfair Terms Directive, and on the other we have the GDPR. The Unfair Commercial Practice Directive and Unfair Terms Directive talk about fairness in contracts and practices, commercial practices. The GDPR talks about fairness in processing. And if we take one step further back, the rationales for consumer law can be found more or less in the data protection law also. For example, like consumer law in the EU is very much affected by traditional economic theories. It is affected by behavioral economics. It is affected, of course, by like fundamental rights discourse. It is affected by competition law. And the thing is that if we examine like why we started having data protection law, it's more or less, at least in EU level, the same kind of like arguments that we find. I mean, we talk about a lot about control efficiencies, behavioral patterns, how data subjects, for example, choose to like consent. So much of the discussion seems like it is, in a way, repeating itself. And if we even see like authorities in the EU, for example, the European Data Protection Supervisor stated that data protection and consumer laws share common goals of redressing imbalances of information and market power. And similarly, as I said, the number of consumer and competition authorities have used consumer law in order to scrutinize contractual terms associated with the processing of personal data, as well for the assessment of the fairness of commercial practices by traders linked to such transactions with personal data. We have also some cases, very few still, but nevertheless, for example, the Italian Council of State, which is the Court of Appeal for administrative law cases in Italy, has recognized, for example, that the provision of personal data constitutes a remuneration, and that consumer authorities may therefore fine traders that act unfairly. And then if we go like on an EU level, in 2016, I think it was, the Commission provided a guidance document on the implementation of the Unfair Commercial Practice Directive, which is a directive that we have since 2004. Anyway, but a new guidance document came out, and it included some thoughts related to how consumer law has the potential to become involved in cases where consumers' personal data are processed by traders. And according to the Commission, this argument is based on the economic value of consumers' personal data. And information related to this value may not, should not be omitted, since it constitutes material information for consumers and how they decide. So, according to the Commission, the whole idea of applying consumer law is about transparency and about rational economic decision making. So this is the direction that the Commission gave to like protection from processing of personal data. And here we find, as I said, that many authorities in the EU that have taken some decisions that are related to the matter. For example, the Hungarian authority, consumer authority, in the Google Aula, I don't remember how it was called. Anyway, case, they said that the information there was not in plain language, so it was a matter of transparency again. And information about how much data is to be seen, is to be seen as information about the price. So it is an information that has to be given because it affects the transactional decisions, or they called it actually business decision there, anyway, of the consumer. Then we see the AGCM, which is the Italian competition authority, which is also the consumer authority in Italy. In the WhatsApp case, they also used consumer law, and the problem there was that WhatsApp, or what the consumer authority, the Italian consumer authority said was that WhatsApp forced consumers to accept the sharing of their data with Facebook by concealing the fact that they were, for example, not required to do so in order to continue using the service. And the same was the case with BEUC, which is an overarching, an umbrella organization of European consumer organizations. That especially the main argument there was that although in theory users could decide to turn to other messaging apps and therefore quit WhatsApp, they would if they would do that, this would happen at the expense of losing most of their contacts. So for many people, according to BEUC, leaving WhatsApp is not an option because of the strong network effects and the lack of interoperability with other messaging services. And this was it was called as a psychological blackmailing. And for that reason, it should be considered as an aggressive, like, an aggressive commercial practice. Then we also have two cases, again, from the Hungarian authority and the Italian consumer authority that had to do with Facebook, and the claim of Facebook that Facebook is free and it always will be free. That this claim was misleading because it's not free, because according to their arguments, we pay with our data. And here we also have to remember that, for example, in the US, data protection issues are seen as consumer law issues. There's the FTC, that is normally the authority that takes care of such issues. Okay, there are also some federal like laws, but in the general, I mean, the idea is that it is about consumers when it comes to data protection in commercial like context. But my question is, okay, still, why are we going to do that? I mean, we already have like a framework that is quite, I mean, it exists since the 90s, the beginning of the 1990s, and we made a big change here in Europe in 2016 with the GDPR. So why are we doing that? Is it about logistics, because we have more authorities that can take care of problems that are related to personal data processing? Or is it a matter of substance, a matter of substance in law? So what is the added value? Like, does fairness and consequently also protection refer to different things between this, when it comes to consumer law and data protection law? And this is why we want them in a way to cooperate for the same thing. So this is like, again, that was my question the whole time, because the things that it as I will show, there can be like direct effects and also side effects that can be problematic, especially if we consider the traditions that we have both in consumer law and data protection law. So if we continue, like, the question is, okay, we see there are some, there are many things that these two frameworks have in common. And if they have things in common, that means they can have like similar goals. And this means that consumer law, for example, could apply. But then the question is also, okay, should consumer law apply? Because of course, I mean, if consumer law always could apply, then why didn't we do it earlier? There has to be some kind of justification for action. And in this case, there were like some very some arguments that I will try to bring here on why consumer law should apply. And what is important to remember is that I tried to create two categories. One is arguments on the effects, or better said, arguments about the insufficient like effects of data protection law. And then arguments that are related to the conditions that trigger the application of consumer law. So more specifically, like the arguments like brought by authorities, by policymakers, by academia, when it comes to the insufficiency of data protection law for the protection of consumers' personal data, focus mainly on four main points. First of all, consent, which is, as I said, I don't know if it's the same in Brazil, but here, especially before the GDPR, consent was very like, one of the main ways to make possible the processing of personal data. And this is why it was very much criticized, and that's why like many scholars, they started like saying that, consent is an inadequate protective mechanism. So there we see like the first problem with data protection law, and something that consumer law doesn't have as such, is that, consent is very problematic. Then we also have the blurred lines between personal data protection as a right that needs to be protected in itself, and how this right is going to be balanced with regards to other rights, like, for example, the access to information, freedom to conduct business, contractual freedom. Since data protection law is based a lot on, the idea of fundamental rights, and there it's always about, balancing rights. And this makes maybe things a bit, more complicated for consumer lawyers and contract law lawyers, who are not that, we are not so much acquainted to this type of language and this type of, reasoning. So it was also like seen as a big problem. Like, okay, we don't know how we are going to handle it. Then we also have the problem of, over complexity and vagueness. And this was unfortunately something that was, became, at least to an extent, worse after the GDPR, because I don't know if you've seen the GDPR, and again, I don't remember how big the LGPD is, but I mean, the GDPR is like 99 articles, and what is 199 recitals? I mean, it's very big, very broad, and therefore the argument that data protection legislation has become over complex in a way that no actor, consumer, trader, or authorities can properly understand and assess. And I mean, if it's so complex, then of course it cannot apply in an appropriate way, and of course it brings only like disappointment, especially for the data subjects. And there are some interesting like new cases, or at least some opinions by the Advocate General on the European Court of Justice, which are like, I think one of them came yesterday, which are also like very interesting, because we see like changes in the way that we understand data protection law lately. Anyway, I will not get into that, but it was just while we were thinking that data protection law would be a lot more like about protecting, now we have also some ideas where it depends, that maybe sometimes businesses can also like the interests of businesses can prevail. Anyway, but the idea is that it's, as I said, it's a very complex framework, data protection law, and therefore difficult to implement and to assess. And lastly, it's also the argument that fairness when it comes to data protection law is not well defined, or at least not as well defined as fairness in consumer law. And as all these like arguments, I think they're spot on. I don't have like, I cannot say that this is not the case, because for example, like when it comes to data protection law, even though data protection law and consumer law are approximately like they have the same age, consumer law is so much more, consumer law when it comes to the Unfair Commercial Practice Directive, and especially the Unfair Terms Directive that came out approximately at the same time with the Data Protection Directive. I mean, we have so much more case law to work with. So is true that, for example, when it comes to the principle of fair processing, it's so difficult to assess in data protection law based on what the court has said in comparison to what the court has said about fairness in consumer law context. So this is the first group of arguments on why we should use consumer law instead of data protection law. Then we also have the second group of arguments, which is about the conditions, why consumer law should apply based on why this kind of transaction justifies this application. So, as I said, the first big argument is that data processing, or not data, the provision of personal data is a counter performance. And this idea, as I said, it was expressly proposed in the Digital Content Directive. It was not adopted in the final text, but still it created, a specific connection. And I mean, even if we read the Digital Content Directive, it is actually like the language is very, very similar when it comes to payments with money and payments with data. So in a way, it created this, de facto, the connection between providing personal data and counter performance. This idea is based mainly on the economic value of personal data. And under this assumption, payments with data are similar to, or at least have the same function as, payments with money. And the relationship between consumer and trader is to be examined under the lens of consumer and contract law, if this is the case. Otherwise, the bargains between the two parties may, as some have claimed at least, they may suffer substantial unfairness. Consumers provide something that is of great value, personal data, but do not receive an appropriate what some scholars have called synalagma, which is like what you provide as a counter performance. It was also like one researcher put it really vividly. She said that after all, why should Google be allowed to make money on my data while I receive nothing? So this was one, it's a very powerful picture there. And this economic value and the economic interests of consumers are claimed to be better protected under consumer law. Because if it is an economic value and it is an economic interest consumers have with regard to their personal data, as for example, like Van Eyck has said, then why not use consumer law? And according to him, misconduct regarding privacy and the processing of personal data is normally not based on attempts to violate fundamental rights. I mean, the motives of the traders are normally purely economic, They want to monetize the data of the consumers. They don't want to violate the privacy of someone. They want just to use the data and make money out of that. So a market-based approach, as the one in consumer law, seems to be more appropriate in this case. And another scholar, Metzger, also claimed that issues related to consumers should be governed under consumer law because it focuses a lot more on the decision-making process. And in that case, we should use consumer law exactly because, for example, many issues arise in this decision-making phase when it comes to providing your data. And the third type of argument that we find in this group is the one about the social goals of consumer law. And this is an idea that at least here in Europe, it was very popular, especially 80s, 90s, I would say. Many scholars, Wilhelmsson, Geraint Howells, Collins, to name a few, we're talking a lot about that consumer law should have the social phase. You know, it should focus on social goals, and in that case, protect consumers' data and privacy can be seen as one more consumer interest that has to be facilitated through private law and consumer law in particular, because since most of the things in our everyday life get privatized in a way, private law may be the best way to address also issues that are related to, for example, fundamental rights. And here we find also the discussion here in Europe about the constitutionalization of EU private law, which means actually that fundamental rights have an impact on private law and vice versa anyway. And in our case, the fundamental rights that we talk about is data protection and privacy mostly, even though the GDPR talks about all fundamental rights that can be protected under this framework. So yeah, after all, consumer law aims at economic and social benefits, and in that case, data protection law has also a similar background. Again, to see also that these connotations are created for a reason. If we see the history of data protection law, we see also that even though now we perceive it a lot more as a matter of fundamental rights, and previously it was also normally related to fundamental rights discourse, in the EU and even before that, data protection legislation was very much related to economic interests. And we can go back to the OECD guidelines in the 70s, I think it was, which was about making easier, international trading, and how data, the processing of personal data could affect this trading. And the data protection directive in the 90s was also based on, the internal market legal basis, while the GDPR does not do that. But anyway, we see that there is both frameworks seem to have this social and economic perspective at the same time. However, we have some problems here, because first of all, the first question is, do personal data have an economic value in a legal sense? Because of course, everything can have an economic value. If I am, an economic theorist, of course, I can see everywhere an economic value. But in law, we don't see everything as having an economic value in a way that we want to regulate it. And a typical example is, we normally don't talk about an economic value on how much advertisements we see on the internet, Again, or we also can see, for example, cases of, I don't know, in my research, in my thesis, I was talking about reproductive labor, which is, things that we do as spouses at home, which are not regulated under the labor law provisions, but you can also see them as some kind of labor and then try to regulate them through that. But we haven't done it, even though there is an economic value, and there are many, it's so much research on the economic value of this type of labor. So normally we have we have to take an action there in order to say whether something that has an economic value also in a legal sense. And then we also have the problem of fairness, because fairness is a main argument when it comes to why we use consumer law in relation instead of data protection law, because in consumer law we have a better way to understand what fairness is actually. So is it so? I'm not sure, because what the problem is, when we talk about fairness in EU, we see fairness, we see two types of fairnesses here. We see on the one hand what we call procedural fairness, and on the other what we call substantive fairness. And what is procedural fairness is nothing more than how do consumers take decisions, if it is free and if it's an informed choice. And with regard to free, to whether consumers took a free choice, we have three cases from the court, because that's one of the problems that when it comes to whether a consumer has taken a free choice after, for example, a commercial practice. So under the Unfair Commercial Practice Directive, we don't have so much case law. We have only three cases, in the first one was Junte-se, where the court examined the practice of promoting SIM cards with pre-installed and pre-activated internet and email services, where the trader did not inform consumers of the fact that such services were pre-installed and the potential costs of such services. The other one was purely creative, where the court focused on a practice where consumers were given the opportunity to win a prize, however, only after having to pay for the cost of claiming the prize. And then we have also Orange Polska, where the court scrutinized the practice where consumers had to decide whether to enter into a telecommunication contract under the physical presence of a courier. What is interesting in all of this is that even though we talk about aggressive commercial practices, in that sense that consumers didn't have the opportunity to make a free choice, in the end, the court focused almost only in the information that was provided to consumers. And for that, there are some scholars that have criticized the approach of the court. So what is interesting is that, for example, the court, in all three cases, focused on information. And for example, in Junte-se, the court found that promoting SIM cards with pre-installed internet, pre-installed internet as a choice, the default choice was that you would have internet and you would pay for that. They did actually say that this constitutes inertia selling under number 29 of the annex of the Unfair Commercial Practice Directive, which means that this was by definition an aggressive commercial practice. In that case, the court shouldn't make any kind of assessment of how the average consumer would understand this practice, and etc., etc. But what is interesting is that the court proceeded to an assessment of what the average consumer understood and what the possibly transactional decision in this case was. And more specifically, the court did not only state that the products in question were supplied by the trader who subsequently asked for payment without the consumer having solicited the products, but continued with an interesting explanation regarding why such practices are aggressive and unfair. And the thing is that it was the problem there was exactly the information that was given created the impression to the consumer that there was not such default choice. And this is an interesting thing, because we are, in this case, the court actually did not speak about whether the choice was informed, but the question was whether the choice was free. But still, it made this connection with the informed choice. When it comes now to informed choices, EU consumer law either like contains specific obligatory information that has to be provided. For example, we find consumer rights directive that has a specific, like, you know, the obligations of consumers, of traders, sorry. Or we go back to the Unfair Commercial Practices Directive and the Unfair Terms Directive, where traders must provide the information that is needed by consumers in order to take, you know, a transactional decision. So they have to provide the information needed to consumers. Now, when it comes to data protection or the protection of consumers' personal data from a consumer law point of view, the Consumers' Rights Directive asks for information that the trader provides information on the price and the cost of a specific product. However, this can be rather problematic when it comes to personal data, payments with data, as we said, because the notion of payment, price, cost, and all the relevant like notions that we have in consumer law have until now been of a pecuniary nature. And after the Digital Content Directive, which indeed made the connection between, you know, paying with data and counter performances. However, the Digital Content Directive was very clear that prices are for payments and not for personal data. So for the Consumer Rights Directive to apply in this case, so that consumers receive information about the processing of their data, we have actually to make some kind of reinterpretation of this directive, and reinterpretation of what means payment, what means cost, what means price, so that it can be like a part of the Consumer Rights Directive. The only existing obligation in the Consumer Rights Directives when it comes to data processing is with regard to the personalization of a service as part of the functionality of a product. And even in this case, it's not clear how detailed this information should be, since the goal in this case is to make consumers understand how to use a product and not how their data are used by traders in general, so that the traders can make money, because it's about functionality. Anyway, but payments with data, what is like what we can take from the Consumer Rights Directive is that if you provide data, then this Consumer Rights Directive should apply. And the Digital Content Directive should also apply. So the provision of personal data is an enabler for consumer law. But this is something different than saying that consumer law should apply also for the processing of personal data. It's like saying, as a parallel, like, you know, that consumer law is about regulating the payment, while consumer law wants to regulate, you know, the relationship that is created through a payment. So when it comes now to the Unfair Commercial Practices Directive and the information that has to be provided through the Unfair Commercial Practices Directive, the main argument is for its application is based either on the fact that the trader claims that something is for free. As I said, the cases with the Hungarian authority and the Italian consumer authority, or that the trader does not make apparent that she acts in her capacity as a trader. So it's the two cases of the annex that we have in Unfair Commercial Practices. And it's number 20 and 22. However, for that to be true, we should again make some kind of reinterpretation of what we have, you know, of specific notions, and we have to accept that, first of all, the economic value of personal data in the markets between traders is also leads also to the economic value of personal data in a consumer traders relationship. Since what is argued when it comes to whether a service was provided for free or not was that traders could make money out of personal data. However, traders made money on another market. It was a business-to-business market. That does not, by definition, mean that there was some kind of economic understanding, at least from the part of the consumer, that this is also an economic, transaction here. And this is very difficult to say in general, because it's very difficult to make an assessment of the price of data or the value of data. Even if it's like, an abstract term, it's very difficult to say whether this is the case, because most of the times, what we care as consumers is that our data can be used for manipulation, not that the value of the data that I could take and give somewhere else was taken by a specific trader. And then when it comes to number 22 of the annex, with regard to whether the trader did not make apparent that she acted in her capacity as a trader because didn't show that she didn't show that personal data had an economic value. It's also a very new kind of interpretation of this situation, because until now, the normal interpretation by the court was that the trader did not make apparent that acted at all as a trader. That this was the question, not if the economic value of something that the trader took was not economic, or vice versa. So this is quite problematic, or at least it needs an active, it needs an active approach, some kind of action there to say that this is how we are going to understand now this, the requirement of free choice and informed choice. And then if we move also to transparency, for example, consumer law has mainly focused either on the simplicity of the language that is used, or the consequences related to some information. That when traders provide information, they have to make it in a way so that the consequences of this of a specific action of the consumer become apparent. However, since Kassler, one case that we had some years ago, the consequences for consumers that have to become apparent have been of economic nature. The court has always talked about the economic, and it doesn't have to do with how much money somebody should maybe pay, but it had to do with the change of the legal status that some consumers would get, would have more obligations than they would have if the terms did not exist and the default rules would apply. So we either have to accept in this case that personal data have an economic value in a legal sense, or that social and personal effects related to the loss of privacy or other fundamental rights and freedoms should also be included in these consequences, since until now we were talking only about economic consequences. Here we also have to consider that the assessment of whether a practice of a trader has been procedurally fair is to be assessed through the persona of the average consumer, which I think you have also the same kind of persona in Brazil, but you also have the vulnerable and super vulnerable consumer. Here we still work mostly with the average consumer. We don't have some, vulnerable consumers are very small proportion of consumers. And this persona is here in Europe is defined as the reasonably well-informed and reasonably observant and circumspect consumer. And this consumer has traditionally a rather good contextual understanding. And most importantly, she's an actor that actively forms the market with her choices. Here, I mean, we see some changes lately in this kind of very like rigid model of consumer, because we also have to remember a little bit the history of how this model came to be, because it came from a different area, or not different, but it came from fair trading law, which was mostly about taking away any like any issues that could appear in the internal markets. We didn't have to have, it was the internal market without borders. So the consumer had to be a normative persona that was an active, an active actor. And therefore, the idea was that this person was also quite alert in a way. And then this model was like, it continued in in market law through the Unfair Commercial Practices Directive. Now we have, as I said, like we see some call it a wind of change. I'm a bit more skeptical, but we see that at least in some cases, for example, when it comes to our advertising law, we see that, for example, there we find some decisions by the European Court where consumers are not that alert actually, or maybe they miss some things here and there. So there are we see like, some changes in this area, but still the average consumer is like a person that is, it's not a lay consumer, it's not a lazy consumer, it's, a consumer that can act in the market and affect the market. And what is interesting is that this model, the average consumer, which, as I said, started from the fair trading law, it came to market law, and now even in the contract law and the Unfair Terms Directive, we see the court referring to this average consumer, which is the reasonably well-informed and reasonably observant and circumspect consumer for cases that are related to Unfair Terms Directive. And in this area of law, we normally didn't talk about an average consumer. So it's interesting that we see also how, how a specific notion infiltrates in other like sub areas of the same framework. And this also like shows that if we have a very well developed persona, for example, of the average consumer, if we start talking about data protection law, where, as I will also indicate later, we don't have such a persona, we don't have an average data subject, how this can become like it can become a risk for data protection law, that we adopt a model from another well-developed area to a less developed area. Yeah, when it comes to like the last problem here, when we use consumer law, is that when it comes to substantive fairness, and in this case, we mean the fairness related to the consequences following a choice, consumer law has mainly assessed this fairness through the criterion of significant imbalance. However, as I already mentioned, the consequences for the consumer, they normally are seen as economic consequences. Or different input, there has to be a change, as I said, in the contractual obligations of the consumer in comparison to the obligations of the consumer in the case of default rules, or if the default rules would apply. Now, the problem when it comes to data protection is that the default rules, in case the terms wouldn't apply, is the GDPR. And the GDPR is an obligatory obligatory piece of law. And therefore, consumers are, in fact, always, protected through this regime. So if the terms are not in compliance to the GDPR, that means that they are invalid. So in this case, we start like interpreting the unfairness of the Unfair Terms Directive as including also invalid terms. Something that has not been as apparent until now. It's quite new as a way of thinking about unfairness, because otherwise we talk about invalidity. And And besides that, if we see, for example, like the GDPR, you can say also, if I speak to my, I don't know, I haven't kept time actually, so.
We are fine, Andreas. Thank you. We're fine.
Okay. And if we also like come to the, if we examine the GDPR in order to see, okay, if these issues exist in consumer law, and then we go to data protection law and say, okay, how are things there? Like, do we have the same issues, or maybe we don't have at all issues there? So why are we going to use consumer law? And for example, when it comes to fairness, as I said, we don't have so much information. We don't have so much case law to talk about fairness in data protection law, but still, like, there are like, you know, in the literature, we still see that the discussion is about procedural and substantive fairness. But they're a bit different, because when it comes to procedural fairness, for example, if we see like some cases from the court, and especially Orange Romania was interesting, and it referred also to Planet 49, two very like famous cases here. The court defined that the controller is to provide the data subject with information relating to all the circumstances surrounding the data processing in an intelligible and easily accessible form, using clear and plain language, allowing the data subject to be aware of, inter alia, the type of data to be processed, the identity of the controller, the period of and procedures for the processing, blah, blah, blah. Very like, you know, very well defined. And then such information must enable the data subject to be able to determine easily the consequences of any consent he or she might give, and ensure that the consent given is well informed. And what is interesting is that if we go to the Advocate General in Planet 49, he really like clarified the whole like idea there, and said that the information provided by data controllers must be sufficiently detailed so as to enable the user to comprehend the functioning of the cookies. And in this case, not meaning of how a cookie works in technical sense, but what the effects of accepting cookies are with regard to the duration of the operation of the cookies and the question of whether third parties are given access to the cookie. So the idea is that when we talk about, you know, procedural fairness, in case of the GDPR, it's a lot about the effects. Because as the Working Party 29 previously, and now the European Data Protection Board has stated, data subjects should not be taken by surprise at a later point about the ways in which their personal data has been used. And therefore, for example, like when we see about, for example, free choice, because there's also like this kind of procedural fairness in the GDPR. When it comes to free choice specifically, as I said, in consumer law, it was about, you know, aggressive commercial practices normally, and they were connected to information. I mean, the decisions of the court connected free choice to informed choice. While here, I mean, the question is about like how the data subject not only consented in a free way, like, you know, there was no kind of aggressive practice or there was no way of, I don't know, harassment or something like that. But the question was whether the consent was given in an unambiguous way. So in this case, for example, in the GDPR, like if we follow the GDPR and we have also case law in this case, it's not allowed to have pre-made choices on related to giving consent. However, if we see, like, for example, consumer law, like pre-made affirmative choices are not by definition unfair. They are unfair if like specific elements follow, like, for example, well, the consumer didn't have the possibility to examine the information, etc., etc. But pre-made choices as such are not problematic in consumer law, while in data protection law are by definition like an indicate by definition, they constitute consent that is not given unambiguously. When it comes to information, again, it's the thing there. It's like while in
Internet's not working well.
Acho que travou, né?
Travou. Travou, sim. Eu já avisei, ele vai reconectar. Oh, there you are.
Hi.
Hi, we can hear you again.
Yeah, sorry, I don't know what happened. I just maybe my mic got tired of me. Wait, I will try again here, and we go here. Okay.
Yes. We are
Yes. Super.
Yes. Okay.
Yes. So yeah, with I think at least I lost you when I was talking about information, and that in many times in data protection law, information is not about choosing whether to consent or not, but it is about choosing whether you have whether you want to react in processing in a specific processing, because many times, depending on the lawful basis of processing, data subjects don't have the opportunity to choose whether their data will be processed or not. So it's a lot more like it's broader in that sense. And then it's the same with transparency. As I said, it's about the effects and in general, not economic consequences. Here we talk about effects as a very like abstract, you know, in a very abstract like level, because most of the times we just, you know, the argumentation of the court is that it affects the rights. Now it's the right to data protection. Previously it was especially the right to privacy, for example. And then when it comes to the average data subjects, as I said, we don't have something like that, you know. What I mean, we could like in a way try to use some cases, and there was one like Orange Romania, where actually what is interesting there is that the court seemed to adopt a picture of a data subject that is rather lazy, a quite passive individual who does not even bother to read information related to how data are processed. So it was we can say not the exact opposite maybe of the average consumer, but very, very different than the average consumer in consumer law. So when it comes in general to procedural fairness in the context of data protection, next, I was going to make a very like complicated, how do you say, argument here, but I will come to the substantive part, which is also like rather different from how substantive fairness in consumer law is. As I said here, I'm mostly like based my research on the discourse and not so much on specific like cases, because we didn't have cases. I mean, the court has almost, it's only like one reference, if I remember well, to what fairness processing exactly should like contain. Normally it connected that to transparency, but still there is a lot of like, you know, there is like literature that says that there is also a substantive like aspect of fairness in data protection. And if we see, for example, the history of data protection law indicates that there is like every reason to accept substantive fairness as fairness aiming at balancing, information conflicts. As I said, the case law that we have only talks about information and fair processing with regard to information. So in that sense, probably we talk about, how can we create a framework where like information is given to data subjects by traders, and how we balance like how much information is going to be given to them. But for some, at least scholars, there is also another reason that provides some support to the understanding of fairness as a balancing act beyond information requirements. And this is to be found in the charter. And for example, like the court in Bavaria, which is also like a very important case from the European Court of Justice, Bavaria Lager, referred to such balancing acts even in case where the law actually asked only about whether the processing was necessary. Because I don't know if you are acquainted to the GDPR, and I don't know if it's the same in the Brazilian data protection law, but we have like different lawful bases when it comes to why we process data. So we see consent, it's contracts, public interest, legitimate interest. Anyway, from this, like all except all lawful bases except consent, they have the the element of necessity. And actually, I mean, in consent, it's by definition it exists there, because if you want to process data because of consent, then it's necessary that there is consent. But for the rest, you have to make an assessment on whether it's necessary to process data. So in this case, for example, it was about I think legitimate interests. Anyway, it was about a specific reason, a specific law that was talking about whether processing could take place, and processing could take place only if it was necessary. What is interesting is that the court, in this case, even though the only element that should be assessed was necessity, it nevertheless proceeded to it started talking about assessment, make an assessment of a balancing act, in which case it was not only about necessity, it was also about whether the processing was proportional. And it is difficult to say in this case, but the court has in some cases also clarified that if we make a a balancing act, and we try to see whether processing was proportionate in relation to some other interest, we see that mere economic interests cannot prevail normally against some fundamental rights that are more important, and this was like Google Spain was one case where the court said it. And even if we don't, because on the one hand, we can have a balancing act between a fundamental right, like data protection, the right to data protection, or the right to privacy. And on the other hand, we can have, as I said, mere economic interests. And in this case, it's a lot more important with fundamental rights. But one could also argue that, okay, but it's not about only economic interest, it's about, the freedom to conduct business, for example, which is also under the charter here in Europe. But if we examine now the cases related to this freedom to conduct business, if we take as an example Sky Esterreich, one case there, the court said that this right is subject to a broad array of intervention. And in this specific case, I mean, the intervention was about the right to access to information with regard to some, I think it was football games or something. So it was not like such an important, right, we can say. So we see that, when it comes, I mean, there is some kind of like hierarchy, and therefore, like when it comes to the substantive fairness and substantive like protection through the GDPR, we see that we have a different approach in comparison to consumer law, where the only element there, requirement there, was the one of significant imbalance with regard to economic consequences and the default rules of the state. So just to conclude here, like my analysis has shown that this new trend of using consumer law for the protection of personal data does not fit in well to the tradition of EU consumer law as it has been developed until now. So consumer law for data protection is not exactly the same as consumer law for consumer protection. And just like, I mean, the most important thing we can say that, for example, the transparency requirement is understood differently, since it contains also the obligation to inform for things which until now there was no such obligation to do so. When it comes to societal considerations, until now, unfortunately, they have been absent, even though, as I said, in the 80s and the 90s, social justice system movements, they were very much about, the social like goals of consumer law. It was a lot more like, in the end, the economic approach prevailed. Then it's also the significant imbalance seems also to be understood in a different way. If we want to use it in a data protection like context, since now it is claimed that it should like include societal considerations such as privacy concerns. Something that we didn't do previously. We didn't have such considerations so much when we did the assessment of the unfairness, because of course, like consumer law has as a general, like, like idea that it is about societal considerations as a whole. But when we come to the specific assessment of unfairness of terms or commercial practices, such considerations, for example, structural imbalances, have not come to the game. For example, when I was talking about the aggressive practices and the cases that were that I referred to there, Wind3, for example, was one of the biggest how do you call them, ISPs, but still the court didn't talk about this imbalance between this ISP and the consumer. The question became a question of information, not about structural imbalance. So we see, for example, as I said, now when we start the trend of using consumer law for data protection seems to take also such considerations into into the picture, even though we haven't done it until now. And then, of course, it's, the economic value of personal data, which is, I find quite, maybe not like, how do you say, risky, but still it's a new way of looking into personal data. It's very, it can become quite problematic, because if you have something that has an economic value, then it always becomes a matter of how, we don't have like a fair price regime, this was back in the days. Now we don't have that. So as soon as we talk about economic value of something, then it's the market that is going to decide, and it can be problematic if we believe that personal data have, and the protection of personal data has another value also. So the consequences on the one hand is that EU consumer law gets closer to data protection law, and in that sense it could be good for consumer law and the whole social justice movement of consumer law. At least for these lawyers, it's something good. I see very positive things through that. because, as I said, I mean, we start like being a bit more, how do you say, we start understanding the average consumer not only as a very rigid, persona, but it's, it's people behave in specific ways. We have to take into consideration that it's also that it's not only about economic consequences. There are other things that maybe we should take into consideration. So in that sense, I see it as somewhat positive for consumer law. On the other hand, we have to remember, though, that, consumer law is created, the way it's created for a specific reason. And now we start like doing something different. And if we do something different, then the question is if consumer law comes closer to data protection law, then why do we need data protection law? Because at the same time, data protection law is affected very much from consumer law now, if consumer law is used for protecting consumers' personal data. And in that sense, if we can try to give it some kind of, identity, we see that in a sense, consumer law is socialized, while data protection law gets marketized. And as I said, from my research, what I saw is that it can be very risky for data protection law for, again, these regimes that decided at some point that we have two different frameworks. If we never did that, it would be okay. I understand why in the US they have this approach they have, but here in the EU we had, we actively chose to create like two different frameworks. So I see it rather problematic when we start, even though most consumer authorities, they do it for a good purpose, they want to protect consumers and data subjects. But still, it can become, I don't know, it can create a different reality. And I don't know if we want it, if we want this different reality. So, yeah, that was all for me. Yeah, thank you very much. I will stop sharing now, maybe. Yeah.
Thank you very, very much. It's a very hard subject for us to comprehend, since it involves also European law, which is very different in many ways from Brazilian law, Professor Kotsios, and you made it really, really clear. So we thank you a lot for that. I'm looking for you. I don't know where you are in my screen. Oh, there you are, because the slides are not showing anymore. So thank you very much, Professor Kotsios. If students have questions, please share them on our chat. In the meanwhile, Professor Kotsios, we have a different approach in Brazilian law regarding data protection. LGPD was highly influenced by GDPR. So several remarks on our LGPD are really close, similar, because they were directly influenced by GDPR, but we also have other influences on our law, including influence from our consumer law. Brazilian consumer law, Consumer Defense Code, as you know, is a very advanced legislation, and it also influenced our LGPD. Here, this difference that you reminded on vulnerable consumers have a huge impact on data protection as well, because we do not see consumers as an average person, differently from the EU. Every consumer in Brazil is vulnerable because he's not really aware of the risks and he lacks on information. So every consumer is vulnerable. This is a huge difference from EU law, consumer law. And when we talk about data protection, we have an aggravated vulnerability, another risk that he's not aware of the risks he's exposed to. He lacks on information in such a way that our average data subject is not aware of the risks. So the vulnerability is very, very problematic. It's not, we do not have article, anything like that on the LGPD related to vulnerability, but consumer law applies in such a way with LGPD that our consumer system, PROCONs, the administrative authorities, they may also work in cooperation with our data authority. So the first cooperation was made of our data authority was made with the consumer authority. So this is something really particular.
And this is interesting because that's the thing. I mean, and now we have actually cases about, you know, like whether consumer organizations, for example, could make claims based on the GDPR. And this was a question until recently. Now we know they can't do that. But what is interesting is that, I mean, this is one way forward, you know. It's one thing to say that, okay, we want to use the GDPR in order to protect consumers. And it's a different thing to say we will use consumer law, skip GDPR in order to protect consumers. And this is what was interesting. Like, as I said, I mean, at some, there were, like, I think, like, most of the cases I was citing here, except, yeah, no, all of them, they're after, I think, 2016, maybe 15, I don't remember, which is like, you know, it's interesting if we think that the first case in Europe was in the 1999, again with the Italian Consumer Authority that used consumer law for a data protection case. So this is, I mean, as I said, I mean, my question was mostly, why are we going to use another framework when you already have one? Which is, as I said, I mean, even though they are like, they have the similar age, you know, both frameworks, they're as old, you know, consumer law is as old as data protection law, but still, I mean, data protection law is very much regarded as an underdeveloped area of law when it comes to developing notions that we have in there. And as you said, I mean, even in Brazil, you see that there is like, there is like a, some kind of, the more developed area of law, which both in Brazil and Europe is consumer law, affects a lot, you know, the underdeveloped area of law. And I mean, in Brazil, maybe it's not as big of an issue because, as you said, you have a different like approach. But for example, like here in Europe, we have, like, for better or worse, like, have a different like point of view there, because we were thinking that we will use more of, you know, traditional economic theories when it comes to consumer law. And again, it's not like, I mean, it's not that I'm a big fan of this approach, but we have this approach. And I mean, we have to understand, if we change this approach, we have to understand why we do that. Otherwise, it's just because of, I don't know, because it came to be. But I think it's good to reflect a little bit and understand. I mean, if we want to do it like that, then okay, then we take a different approach here, and we do it in general, and not like only in 2-3 cases that have to do with data protection.
I see. And my question for you, Professor Kotsios, is our perspective relates to fundamental rights, as you saw and even said at the beginning in Brazil. The use of this data, how are you dealing with the use? Since I'm using data as a way of payment, it's looks like a property approach. So I transfer data, and in what measure these data are protected after this transaction? Because we have a few concerns related to the use of this data to form a personal, an avatar, as an avatar to what the consumer is. And this avatar with time may be not as actual as the consumer. And this may influence on the access this consumer or this person will have to services, prices, and I would like to hear from you, if possible, on this artificial intelligence perspective and impact on this person's life due to this use of personal data, because this is our approach in Brazil, the fundamental rights. And it's curious, Bruna, our student, send you a message on our chat, telling you and reminding you that here in Brazil we had constitutional amendment to protect data. So the right to protection of data is now, since last year, in our constitution. So this is very huge for us, this fundamental rights perspective. So what mechanisms you have there in order to avoid this lack of access of consumers to services and products, and this price, different prices that may be used due to these transactions on data?
The thing is that, I mean, like if we take, if we see the big picture, I mean, first of all, here in Europe, we also have, it's not exactly our constitution, but we have the Charter of Fundamental Rights of the EU, which is, as our constitution, we could say. It's like a number of fundamental rights that should apply throughout, the whole EU. And we have, interestingly enough, two different rights, right to privacy on one hand and right to data protection. So we made this distinction, and it is a good thing, because they are two different things. On the other hand, it was, I mean, for many years, if we see the tradition of this right to data protection, is very interesting. If we see the cases in the court, like from since 2009, it was like, actually, when it was about protecting personal data, it was about the right to privacy. Then like in 2009, we had one transactional case, we can say. There it was, the data protection was about, like both about the right to privacy and the right to data protection, as something very vague, though, because the charter became, part of our legal, how do you say, part of our legal reality here in Europe in 2009, when it was it was adopted in 2001, and it became part of the EU legal corpus in 2009. So there was like some years that we were talking about that, but it was more of a, it was not well defined. So, and after 2009, we started having more and more the idea of, when we talk about data protection, it's not about the right to privacy, but it's about the right to data protection, which is an autonomous concept. And again, it doesn't have to do with intrusions to your private sphere. It can be it is about protecting your personal data. So in that sense, we do have the same idea. Now, when it comes to, for example, AI applications on based on the processing of personal data, it's a rather complicated issue, and it is very very specific. I mean, the solutions there have to be, the assessments have to be based on the specific cases. And for example, we have an article in the GDPR that talks about autonomous decision making, and that if it affects consumers in a, legally or in a rather substantive way, such decisions shouldn't be taken automatically. There should be some kind of, some human in the loop. So we do have this idea. Then when it comes, for example, to I don't know, commercial practices that are based on the provision of personal data and the processing of personal data, And then we have to see the specific like commercial practice. I mean, if it's like, for example, the idea of how to say it, like personalized prices, it's rather unclear, I would say, because it's difficult to find a specific justification on why not to do that. You know, I mean, it can be like some kind of discrimination, then you will use that. But I mean, if there is a problem with the processing of personal data, that, for example, the consumers didn't know that the personal data would be used for such purposes, then it is a matter of the GDPR, and then we have a breach of the obligation to provide like transparent information. So it's very like the assessments are ad hoc in this case. That you have to see the big picture and then like examine the specific case. And it has to do with most of it. I mean, I don't know, as I said, I don't know how it has, like the Brazilian data protection law has worked. But I mean, here we see also like when we examine the decisions from the EU court, we always see that it's very much depending on the circumstances. One very like typical example is that sometimes it's misunderstood, even here, for example, is that I don't know if you are familiar with dynamic IP addresses, which is like your IP address, like what we use, the address that you have on the internet. For example, it's like most of the times it's dynamic, which means that it changes the whole time, and normally the only one that has like access to this address is your ISP. So there was a case, and it was about dynamic IP addresses and whether they are like personal data, and the court there said that dynamic IP addresses can be personal data, or they were personal data in a specific situation. And this situation was that in Germany it was an authority that was gathering dynamic IP addresses. So actually they couldn't know like the person that was behind this IP address, but such as an authority, they had the possibility to get access to an ISP and be able to find the person behind the IP address. So in this case, it was found to be like a personal data, but that doesn't mean that in general dynamic IP addresses are personal data. And this is like, I mean, a very basic thing that normally everything can be personal data, but even there we see that it's so much related to the situation and the circumstances of a specific case. Oh.
I see. Thank you. We have two questions more from Wilma. If you have time for two more questions.
Yeah, of course. Yeah.
Yes, and the chat, Wilma asked, he's stating that the use of personal data helped in some cases during the COVID pandemic. Through some apps, it was possible to know where there were fewer agglomerations, so it was used for that in that sense. He asked if you think that in some cases it's possible to make data protection more flexible with the justification of a pandemic or some reason like that. And the second question is from Webster. He wants to know how the authorities, the data protection authorities, are working on the state's members. If this cooperation, how it's working, if they're helping with the regulation, if you may say something about that.
I mean, so the system here in Europe is that every member state has its like data protection authority. This data protection authority is responsible for everything that happens in this member state. So they are very like they have quite a lot of things to do, and this is also an argument that comes from time to time that they don't have that they cannot like look into all problems. But anyway, the idea is that there is the data protection authority in every state, and then we have the European Data Protection Board, which now is like an EU organ. And in this case, the European Data Protection Board, like the purpose of this board is that the data protection European data protection law is interpreted the same way throughout all member states. And this is like the idea. So there is quite close. I mean, yeah, they do help in the development of the, you know, of the interpretation of the GDPR a lot, the local authorities and then the European organ. So, but still, the problem is that, I mean, they're authorities. So, and we don't have so much like case law from the EU court. Now it's, I mean, it has like, I mean, we have a lot more cases than we have with the data protection directive, so we can't complain the whole time. So we do get more and more like case law, but still it's not that much. And this is one of the risks, that if we start using like consumer law and we start examining like consumer law, data protection as a consumer law issue, then the case law is going to be consumer law case law and not data protection. So we are going to leave data protection underdeveloped in that sense. But the data protection authorities are very active here. I mean, I don't know if you have the time, but there is what is the name? Data protection tracker or something like that. There's a web page with all like fines that came from every like European data protection authority. And I mean, now like the last few years, it's like, I don't know, it's like so many cases that come from you know, decisions that come from authorities, European authorities. And then when it what was the first question? With the pandemic and everything, the things that I mean, this is also something that is very, an idea that is rather not twisted, but it's not exactly, it doesn't show the spirit of data protection law. We consider data protection law a lot as a very like rigid framework that, you know, if you do something, you are like, it's very, you know, it's very important to be in compliance and to be very like, you know, very take small steps all the time and not do so much and everything. But I mean, the idea is that data protection law is about flexibility, that it has to take into, and I mean, what is interesting is that, I mean, even the application, like applying consumer data protection law, you know, as a company, for example, as a trader, I mean, you have to do the assessment. And this is quite new as an idea of, you know, regulating an area. I mean, so much about self-assessment, which means that the point is that you have to find the right arguments to weigh the different interests. If there are like good reasons for like, you know, processing personal data, I mean, of course you would have to do it, as long as you also take into consideration the risks that can appear in this case. So in that sense, I mean, data protection law is, I see it as a very, very flexible tool, because it's really like, I mean, it gives so much space to the actors to decide how they're going to do it. You know, it's very like, I think it's a very new way, as I said, of regulating. Also, we didn't have this approach, and we see that now we try to step back a little bit. For example, like if we see now the proposal for the AI Act, which is about regulating AI systems, we see that now we don't want actually, you know, like traders to make assessments on whether something is of high risk, of medium risk, or low risks. Now the idea is that we come back a little bit more, that the regulator is going to say exactly, okay, this is high risk. You know what? I don't know. You will not make an assessment on whether this is high or low risk. While in the GDPR, for example, it's up to the controller to make a risk assessment and say, okay, this is a high risk, like processing. And if it is a high risk processing, I still can do it, but I have to take into consideration specific things, and I have to have like specific, safeguards, organizational and technological, etc., etc. So it gives you like the opportunity to create your framework there. So in that sense, I think it's more that we are afraid because it became, at least here in Europe, it was a very like, I don't know if any of you like followed how it was here, like when the GDPR would start like, being implemented in the different states. And it was like panic. And I understand why it was panic. I mean, I was like cooperating with some banks, and they didn't know what they had for data. They didn't know what they were doing. So in that sense, I understand why they were panicking. But it's also like, I mean, the point is that we try to create something that is, that is valuable for society, and that, I mean, as I said, the lawful basis of the GDPR is Article 16 of the treaty, which actually refers to the right to data protection as the charter. So it's not based on the old Article 114 of the treaties of the functioning of the European Union, which was about the internal market. So in that sense, the first thing that we have to do with data protection legislation is to protect the data. But the tradition, and also like we have like references even in the GDPR, that the internal market has to function as long as you protect the data. So we want to have like a free flow of personal data as long as these personal data are protected. So the problem here is just to find a way to protect them. In that sense, I would say that it's very flexible, piece of law that I think it has gotten a rather like, bad name in a way. And I understand why, because as I said, it's very complex, it's very big, it's very difficult to interpret it because we don't have like, the tools that we are used to have in order to interpret case law, etc. But still, I mean, I think that the spirit of the GDPR, and if we see like the broader discourse on data protection, is about flexibility and trying to create like value for society in general.
We will have to schedule another class with you to hear about the AI Act. This is very interesting, the proposal. I remember the panic in 2018 when it first came to force. I was in Europe, I was in Germany by the time, and I was overloaded with emails. Please sign it, read and sign our terms and conditions. And it was really something incredible. And people were saying, I went to the dentist and he made me sign that I agreed that I would see my name and email. And people really complaining, and it was an overload of information.
As I said, I think this is why, I mean, we started a bit wrong with the GDPR. I think it was, I mean, the idea was like to create, an atmosphere where traders would become more aware of what they do with data. Because as I said, I was also like very shocked with some companies that I had some cooperation because of my research, and they were like, we have no idea what we were doing. Like, it takes so much time just to put everything together. And it's like, okay, then you really you didn't follow the law previously. Yes. So that, I mean, that is what was the problem, And now it's not the GDPR that is problematic. It's just that you never cared about it. And now that you hear that it's going to be, these fines and everything. Yeah, yes, now you're like, okay, now we have to fix it. So it's really a very, as I said, I mean, I think it's very, I don't know, a very interesting case, GDPR in itself, I mean, I could just talk about it, I don't know, for ages, the whole process and everything.
Yeah, here's the same, but we do not have fines yet. And one fine was established by our national authority on data protection. I think this panic will come when they do the first one.
Yeah.
The law is already enforced since 2020 here. 2020.
What is interesting is that I don't know if it's the same in Brazil, for example, but first it came with the GDPR, these really high fines, and apropos how one area of law affects the other, and now what they have done is that they've taken the same kind of fines and they put them on, in like most consumer law legislation, so that it's exactly the same, like what was it, like 4 or 5% of the annual, and now with the AI Act, they even raised it a little bit. So it's really it becomes more and more this is, I don't know if it's because it was this panic and everybody cared about the GDPR in 2018. Maybe this is why, but it seems that they've seen that something worked there, and they're like, okay, we will take it now and we'll put it in consumer law, and
make it at the level. Well, Professor Kotsios, I have no way of thanking you more. We are really thankful for your time, for being here with us. We wish we could stay the whole day with you, and maybe we could reschedule another class in AI Act. We really appreciate. Thank you for taking time from your girls to be here with us, and we really appreciate. We will talk in the afternoon in Portuguese of your class, and will be great. I'm pretty sure students liked it a lot. And I was thanking Professor Kotsios this week. How could I thank you? And I wanted to send a gift to your girls, but it's impossible to send a gift online. So I thought that maybe a way of thanking you and thanking them for giving us time with you was giving them a joke. So I have a joke for them as a gift for your time. And the joke is, why is 6 afraid of 7? Because 7, 8, 9.
I have to find a way now to translate it to Swedish or Greek.
Or Greek.
But the thing is that I'm really happy that I could be here actually. So I'm really looking forward to future, being here again in the future. And if you want anything, you can always mail me if you want to ask something. And again, I'm really happy that I was here, even if it's on Zoom. It's always it was an honor. Thank you very much, everybody.
Thank you, Professor Kotsios. Great evening for you now, and thank you again. Bye. See you later. Pessoal, voltamos então às 14 horas com a nossa rotina. A gente avançou um pouquinho no horário, então retomamos às 14 horas, ok? Obrigada, até breve. Obrigada, produção.